emerging from Article 200 is rejected. C99. Page 8586. PGF 152. Paragraph 99, Mullah, if I may.
Paragraph 99.
99. On the issue of discretion, the learned senior counsel placed reliance on 163(2). Based thereon, it was submitted that the governor's discretion for all intents and purposes must be deemed to be final. It was submitted that since 163(2) itself postulates that the decision of the governor in his discretion shall be final, and the validity of anything done by the governor shall not be called in question on the ground that he ought or ought not to have acted in his discretion, by itself absolves the governor from a challenge to the discretion exercised by him. Precisely the argument. It was submitted that 163(2) was neither a defunct nor a redundant provision, and as such it could neither be overlooked nor ignored. It was contended that the words employed in 163(2) must be given due weightage. If that was to be done, there could be no doubt that the discretion exercised by the governor under 163(2) would have to be considered in a manner as would protect him from the scope of any challenge. These are the contentions. Now I tell you, rejected. 147 and 149, if I remember.
Paragraph 147?
147.1, I think. 1 point, yes. Actually, it starts from starts at page 8617. So that's 147.2. 1. The executive functioning of states is provided under Part 6.
Paragraph?
Para 147.1. Well, just come, let's skip I need not read the entire paragraph. Kindly read between placetum D and E. Starting, the question that will need determination at our hands. Your Worship has that? Between D and E. The question that will need determination at our hands is whether the underlying cardinal principle with reference to discretionary power is to be traced to 163(1) or from 163(2).
Where are reading?
Whereas between D and E, 147.1, starting, the question that will need determination.
Yes.
Lordship has that?
Yes.
At our hands. Is whether the underlying cardinal principle with reference to the discretionary power of the governor is to be traced from 163(1) or 163(2). Whilst it was the contention of learned counsel appellants that the same is expressed in clause 1 of 163, the contention on behalf of respondents was that the amplitude of discretionary power of the governor is evinced and manifested in sub-clause 2 of 163. Undoubtedly, all executive functions of the governor of a state are expressed in the name of the governor under 166. That, however, does not per se add to the functions of the powers of the governor. It is also necessary to appreciate that in the discharge of executive functions, the governor of a state has the power to grant pardons, reprieves, respites, remissions, or punishments, or to suspend, remit, or commute sentences. Governor's power under 161 is undisputedly exercised on the aid and advice of council of ministers. The governor has power to frame rules for convenient transaction of business. The instant responsibility is also discharged on aid and advice. All in all, it is apparent the governor is not assigned any significant role in the executive functioning of the state. We therefore endeavor to examine the duties and responsibilities of the governor, and then para 148 at 18618 PDF 184. That's the final conclusion. 148. The above position, Lordship has that? The above position leaves no room for any doubt that the governor cannot be seen to have such powers and functions and was assigned to him a dominant position.
Which is that paragraph?
148.
8618.
8619. Yeah.
8618.
18, not. Continues over page.
I continued over the.
Yeah.
148.
148. I just read that. That really answers everything. The above position leaves no room for any doubt that the governor cannot be seen to have such powers and functions that would assign to him a dominant position over the state executive and the state legislature. The interpretation placed under 163(2) on behalf of the respondents has just that effect because of the following contentions advanced on behalf of respondents. Firstly, whenever a question arises whether he is discharging a particular function, the governor can or cannot act in his own discretion. According to the respondents, the discretion of the governor on the above question is final. Secondly, since the provision postulates that the decision of the governor in his discretion shall be final and the validity of anything done by the governor shall not be called in question on the ground that he ought or ought not to have acted in his discretion, according to the respondent, makes the governor's orders based on his own discretion immune from judicial review. Accepting the above proposition will convert the governor into an all-pervading super-constitutional authority, which Dr. Singhvi read. But it was important to read to go to the alap Malats before we came to the conclusion. This position is not acceptable because an examination of the executive and legislative functions of the governor from the surrounding provisions clearly brings out that the governor has not been assigned any significant role either in the executive or in the legislative functioning of the state. That position adopted in behalf of the Samad. So this Malad rules out any possibility, and this is a constitution bench. Malad, that's all reflected in my propositions. So I'm not going to read them, Malad. Why waste time with your lordships, Malad? Now,
149 refers.
Malad, there's also 154.
What?
154.
149 refers.
Yes,
The
149.
constitutional debates and
Correct.
Dr. Ambedkar's.
Correct. That also. Your lordship is absolutely accepting the approach. And then, yes, all that will, Ambedkar is quoted and all that. And then it comes to one.
These debates were already.
Yes, therefore, I'm not going to take. Then come to 154.
622.
No, page 8622. Malad's PDF 188. But just above 154, Malad, just 5 lines above the previous paragraph, it is therefore clear, that is placetum, just above placetum B, A and B, the sentence, it is therefore clear. It is therefore clear that even though the governor may be authorized to exercise some functions under different provisions of the Constitution, the same are required to be exercised only on the basis of aid and advice tendered by, under 163, unless the governor has been expressly authorized by or under the constitutional provisions to discharge the function concerned in his own discretion. But this is why I said in the opening, Malaj, 200 is not one such provision. It's a constitutional obligation. You give him discretion, the Constitution will break down.
You gave yesterday, for example, 371A1B.
Yes.
Where the discretion is.
Exactly. A1H 371. And that way the executive field, it's an issue of law and order. Manas, even there, the discretion is qua law and maintaining law and order. It is not with reference to any legislation. Even that discretion, Manas. Because otherwise he is to be guided by the advice of the council under 371A, Manas. There is a Hills Council, there are councils, Manas. So he may differ with that advice. And then if he differs that advice, that discretion is final in respect of law and order. Again, nothing to do with legislation. It can't be, Maharaj. It will be contrary to all principles of constitutional law if you start giving the governor that power. We're not going to have to find a solution, Maharaj. I come to that later. But first, let's be clear on the constitutional framework. We come to the solution in a while. So then it says, Mullahs, it is therefore clear that even though the governor may be authorized to exercise some functions, this is between A and B at page 8622, under the different provisions of the Constitution, the same are required to, I've read that. Then 154, we therefore, of the considered view that insofar as the exercise of discretionary power vested with the governor is concerned, the same is limited to situations wherein a constitutional provision expressly so provides, not by implication, expressly so provides that the governor should act in his own discretion, which is 371A, etc. Additionally, a governor can exercise his functions on his own discretion. Additionally, on own discretion in situations wherein interpretation of the constitutional provision concerned could not be construed otherwise. We therefore hereby reject the contention advanced on behalf of the respondent that the governor has the freedom to determine when and which situation he should take a decision in his own discretion without the aid and advice of the Council of Ministers, Chief Minister and Council of Ministers. We accordingly also turned down the contention that whenever the governor, in the discharge of his functions, takes a decision in his own discretion, the same would be final and binding and beyond judicial review. We are of the view that the finality expressed in 163(2) would apply to functions exercised by the governor in his own discretion as are permissible within the framework of 163(1). And additionally, in situations where the clear intent underlying a constitutional provision so requires, where the exercise of such powers and the aid and advice would run contrary to the constitutional scheme, or would be contradictory in terms. So, Mullahs, this clarifies many of the things, Mullahs, that have been contended on the other side. Now, Mullahs, my submissions. Para 14, yes. Now, Mullahs, another provision which I think my learned colleague, Mr. Kaul, referred to, which I think is also important, 167 of the Constitution. There are two provisions that are important for your lordships to consider, 158 and 167. First, 158. The governor shall not be, my lords have that. The governor shall not be a member of either House of Parliament or of a House of the Legislature of the state specified. The reason why he is given a position is because he is to act for the well-being of the state, which is why he is included in that in the provisions of the Constitution. Because he is acting on the well-being of the state. But he has no legislative role. Just that, because I just wanted to invite your lordship's attention. Now 167. My learned friend Mr. Kaul referred to it. Rightly so, according to me. And this is where the hub will lie, Mullahs. Yeah, Mullahs?
Yes.
Yes. It shall be the duty of the Chief Minister of each state to communicate to the governor of the state all decisions of the Council of Ministers relating to administration of affairs of the state and proposals for legislation. To furnish such information relating to the administration of the affairs of the state and proposals of legislation as the governor may call for. And if the governor so requires, submit for the consideration of the council any matter on which a decision has been taken by a minister, but which has not been considered by the council. So, Mullahs, this is a pre-legislative process exercise, which gives you an indication of the contours of the power if it's to be exercised under 200. Mullahs, why your lordship sees so often, and your lordship knows, every time, Mullahs, the Prime Minister will go and brief the President as to what has happened. If he goes on a trip, he'll come back and brief him. If there are any proposals, he'll come back and brief him. There are, Mullahs, one nation, one election, he'll go to the President that, this is what we're contemplating. President may, in that informal discussion, This is Q 167. You have another provision, the same provision under the union. He will, have a So that's where the cup of tea happens, mothers. Not later. Exactly.
Not a cup of tea between your CM and the PM.
Yes. So this is where all the cobwebs are cleared. Once the cobwebs are cleared and the bill is sent to him, there is no occasion for him to say no. You have to work it out, mothers. We have to work out the scheme. So that's where, that conversation takes place. And then when the bill is sent to him, then he cannot say, I know I'm not going to accept it. I'll wait for 1, 2, 3, 4, 5 years.
From both sides, right? Except we don't permit the constituent authorities to.
Yeah, I've done that, mothers. Yes, I've done that. Yes. I remember when S.V. Gupte was the Attorney General at that time as a young man, maybe 28, 29, and I briefed him in a matter, and we were in outside court number 1. And the matter was reaching, and he was smoking with us. And I said to him, the matter is reaching. He said, yeah, it's all right. And it almost reached. He said, you go. You argue. This is the kind of seniors we had. Now you want to take over even what the junior argues.
Therefore, we have stopped mentioning in the.
Now, serious
So glad.
orders.
I am so delighted, Mulas. That's the right thing to do.
Yes, I will.
Why should senior appear in vacations?
Yes, correct.
You should have this thing.
There is in my court
Practice procedure, Maharaj, should not appear in vacations. Anyway, that's another matter. I'll get into trouble with that.
Seniors need to get more disciplined now.
Today only, I think you have exhausted all your 3 terms.
More or less. I'm going to, but as I said, within.
You are exhausted all your 3 terms.
Oh yes, of course.
You don't have to bother about that.
No, but Maharaj, one is bothered for the institution. All kinds of things happen, Maharaj. Suddenly you find that your case is reaching somewhere else, so you stop the argument. This is not what. Anyway, that's another matter.
Yes.
Kindly come to Maharaj, back my volume 2.5. So, Maharaj, I was at. Yes, I've already argued that what is there, Maharaj. I'm going to read it.
You're done?
I've argued. No, not yet. No, I will finish within the 4 hours given to me. Maharaj, I'll try and, in fact, give more time to others. Because there's no point repeating things.
Mr. Sibbal?
4 hours.
No, this says 3 hours.
That I don't know. I can finish in 3, no issue. I have no problems with us. And let us kindly come now to paragraph. I've done paragraph 15, 16. Then you come, I've also done 17, 18, Naban Rebia. I've read all that. Then page 899. 21, declare I've already done that. I've already done it. Well, let's not take the time of the court. Practice, Mullah. If council do not sit in constitution bench matters throughout, they will be heard last. They'll make them sit, Mullah. Sorry, Mullah.
And by that analogy, Mr. Gopal Subramanian should have been the first one.
I'm ready. No, but we sat all throughout, Mullah. We were there throughout. It's only
But
some comfort break occasionally, Mullah.
in between you going out for some time, but
No, Mullah.
sometime yes, we have seen.
Only to get the matter adjourned of that sort of pro bono matter.
But you took some 5-minute or 10-minute intervals.
Yes, but he's been throughout
He
here,
has been from morning to evening.
which is why I've parted with Mullah, the state.
and glued to the seat right from morning to evening.
Yes. And that's been our practice more or less, Mullah. Now, sir, I've done declare issue, Mullah. I've already indicated what that means. Then then Mullah, 356. 356 is completely irrelevant to this issue. Because 356, again, as I told your lordships earlier, the only power of the governor under the constitution is either to accept what the legislature says or recommend. There is no third power of the governor under any provision. 356, he recommends. On what basis? On basis of satisfaction. Question of satisfaction is subject to judicial review, but not the judicial review that we contemplate qua administrative action. That's limited. He has taken irrelevant considerations into account. That doesn't apply to 200. 200 doesn't deal with either satisfaction or discretion. So those arguments, those submissions that they made under 356 have no relevance. On 161 pardon, again, it doesn't apply. And on 311.2, just see Mullah 311.2. That's the other area. There are only 3 areas. And all recommendation. 311.2.
You read it yesterday?
No, I didn't. 311.2, I didn't read.
No.
I mentioned it, I didn't read it. 111 I read, not 311. If you see 311 and you see, Mullah, the proviso to subsection 2, sub-article 2. It says, I'm sorry, Mullah, provided that where it is proposed that after such inquiry to impose upon him any such penalty may be imposed on the basis of the evidence adduced during such inquiry, and it shall not be necessary to give such person any opportunity of making a representation on the penalty proposed. Provided further that this clause shall not apply to come to B, where the authority empowered to dismiss or remove a person or to reduce him in rank is satisfied that for some reason to be recorded. So that's the other area. See that where the president of the case is satisfied. So both 356 and 3112 proviso deal with satisfaction.
Subject to satisfaction.
Yes, not relevant as far as 200 is concerned. So all this is recommendatory. Governor has no power. So either you comply with the legislation as proposed to you, or you recommend. Send it back, a recommendation. Send it to the president, a recommendation. No power. If you read into that a power, it will be contrary to this entire constitutional scheme.